Alright, so in this lecture, we are going to look at the significance of Constitution of India as part of Indian polity. Indian polity has two parts, first being the study of the Constitution of India, second being democracy at work. We'll begin our journey with the question, what is Constitution of India? More importantly, why do we study the Constitution of India as a civil services act? And thereby arriving at the Constitution and at its significance. So, first up, what is Constitution of India? So, Constitution of India is a legal document. That is, its provisions are legally enforceable, violation of which invites legal punishment. So see, Constitution of India is a legal document. Now, what do we mean that it is a legal document? It simply means that its provisions are legally enforceable. And violation of the provisions are legally enforceable, and violation of what? Of which the provisions? The violation of the provisions invite legal punishment. So, let's understand what do we mean by provision. What do we mean by provision? So provisions here means the content such as the preamble, the parts, content such as the preamble, which we'll get to in a minute, and parts, schedules, etc. Let's focus on the parts. Well, our constitution has 470 articles. They have been grouped together in 25 parts. Now, each part represents a theme. For example, part 3 represents fundamental rights. So, in part 3, under Article 17, untouchability has been abolished in all its form. That is, untouchability cannot be practiced in any form in India. Now, suppose the person in the picture is practicing untouchability. Now, Article 17 has abolished untouchability. It says that untouchability cannot be practiced, but the person is practicing. Therefore, he is violating Article 17, which is, this Article 17 is contained in part 3. This Article 17 is part of part 3. Therefore, he is also violating, the old man is also violating part 3. Now, part 3 is the content of our constitution. So this person is also violating the content, and content is what we mean by the provisions. So the person is also violating the provision. So upon the violation of provision, he can be punished. Can be thrown behind the bars. But he can be thrown behind the bars legally. So Constitution is a legal document. The provisions are legally enforceable, and upon violation, legal punishment is attracted. I hope this is clear. Alright, now let's look at the preamble. Preamble contains the essence of the Constitution. And the preamble says, "We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual, and unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Well, Constitution contains the faith and aspirations of we the people of India. We the people of India have faith in certain values such as sovereignty, such as socialism, secularism, democracy, republican form of government. Now, are the objectives. Aspirations are the objectives which we the people of India wish to achieve for ourselves. We wish to secure justice for all, assure liberty of thought, expression, belief, faith, and worship. We want to ensure equality of status and of opportunity for everybody, thereby promoting fraternity. Fraternity is the feeling of oneness, the feeling of being the sons and the daughters of the same soil. So what does the Constitution do? Constitution enumerates. Constitution contains the faith and the aspirations of we the people of India. We the people of India have faith in principles such as sovereignty, democracy, republican form of government, and our aspirations, we wish to achieve justice, liberty, equality, want to promote fraternity. So the Constitution enumerates the higher values which we hold for ourselves and the higher goals which we wish to achieve. I hope I am clear up till here. So far we have seen that the Constitution, so we are trying to understand the significance of the Constitution of India. And so far we have seen that it's a legal document, that its provisions are legally enforceable, and violation invites legal punishment. And Constitution contains the higher values and the higher goals which we wish to achieve. All right. Constitution is also known as the supreme law of the land, which is an American concept, supreme law of the land. In order for us to understand the supreme law, the phrase supreme law of the land, let's first understand the phrase law of the land. Well, law of the land is collection of all the laws, is sum total of all the laws that are required, that are used for the administration, that are required for the good governance of the country. So law of the land, we are trying to understand what do we mean by supreme law of the land. In that we saw what is law of the land. It is sum of all the laws that are required for the administration of the country. But what is law of the land? What consists of the law of the land? Well, law of the land consists of the Constitution, the statutory laws. The statutory laws are the laws made by the Parliament or the state legislature, but not the laws made by the local self-government bodies. The laws made by the local self-government bodies are called bylaws, and they are subordinate to the statutory laws. Example, Right to Information Act, which we are aware of, is a statutory law. Then we have ordinances. See, statutory laws are made as and when the Parliament is in session at the center. But what if the Parliament is not in session and a law is required? In that case, the President will promulgate the ordinances at the center. and the same work is done by the governor. So far we have seen three of the laws, but what if there's a confusion, if the laws if the law made is not clear, if it is vague, then who would interpret such law? Well, the power to interpret the law is bestowed on the judiciary. So at fourth we have judicial decisions made by the Supreme Court or the higher court, which together is also known as the higher judiciary. Supreme Court plus the high court together is known as higher judiciary. Example, right to privacy. See, under part 3, there's nowhere right to privacy is nowhere explicitly mentioned under part 3. What do I mean that it's nowhere explicitly mentioned? Explicitly means openly. It's nowhere mentioned openly. All right. So it is the Supreme Court in particular which interpreted the right to privacy as an inherent right under Article 21, that is right to life. Right to life. So it is Supreme Court which says that right to privacy is implicitly available under the right to life, which has been given under the Article 21. What do I mean implicitly available? Implicitly available means it is available there, but not openly written. All right. And at 5, already discussed, we have bylaws, laws made by the local self-government bodies such as the municipalities and the panchayats are subordinate to the statutory laws. And C, the laws discussed so far, they contain the basic framework, but they lack the ground reality. Now the ground reality is provided by the government for their implementation. When laws are made, they lack ground reality, and that ground reality is provided by the government in the forms of rules, regulations, orders, directions, notifications, etc. So at number 6, we have rules, regulations, notifications, orders, directions issued by the government. And at 7th, we have the customs that enjoy the force of law. Customs that enjoy the force of law. What do we mean by this? Let's understand this. See, among Hindus, it has developed that when an adult male and an adult female undergo a series of rituals culminating into them taking 7 rounds of holy fire, their marriage is considered to be solemnized legally. See, let's understand this. Taking rounds taking rounds of the fire is a Hindu custom, and it provides the marriage religious sanctity. But that custom has also gained the recognition of law. And the marriage is not only considered to be solemnized religiously, but also legally. In other words, the man cannot say that he took the rounds of the fire as the night was cold and deny the marriage and the woman. All right, coming back. So we are trying to understand the law of the land. And law of the land consists of the constitution and the Then we have statutory laws at number 2. Then at number 3 we have ordinances. At number 4 we have judicial decisions. Number 5 we have bylaws. And at number 6 we have rules, regulations, etc. made by issued by the government. And at number 7 we have the customs that enjoy the force of law. Now the numbers here represent the hierarchy. The numbers 1 to 7 represent hierarchy. Now the constitution, being at number 1, is the supreme of all the laws. All the laws must be in conformity with the constitution, or else they are declared unconstitutional by the judiciary, and hence they stand void. And this is what we mean by saying that the constitution enjoys a special legal sanctity. That the constitution enjoys special legal sanctity, whereas all other laws enjoy legal sanctity. See, all other laws are legally enforceable, whereas the constitution is especially enforceable. Therefore, in order to be enforced, the other laws must be in conformity with the constitution. Well, if you want me to take an example, then we can take the example of talaq-e-biddat, the instant talaq, which was practiced by Indian Muslims. Not going into the details of it, but see, under Article 14, we have right to equality, and instant talaq, the triple talaq, was placing, though earlier had legal sanctity, was a custom which was enjoying the force of law, but upon judicial scrutiny was found to placing the Muslim women at a comparative disadvantage with respect to the women of the other religion and also the Muslim men. So therefore was declared unconstitutional, and therefore was declared void. I hope I am able to convey myself. See, under article we have equality, but talaq-e-biddat or instant triple talaq was placing the Muslim women at a comparative disadvantage in comparison to the women of other religions and also in comparison to the Muslim men. Therefore, talaq-e-biddat or instant triple talaq was not in conformity with the Article 14, was not in conformity with the Constitution, therefore was declared unconstitutional and hence void. Let's also understand one more thing. See, all the laws from 2nd to the 7th, all the laws from 2nd to the 7th, except the first one, are non-constitutional laws. Are non-constitutional from 2nd to 7th, and the laws in the Constitution are constitutional laws, whereas the laws which are outside the Constitution are non-constitutional laws. See, non-constitutional law does not mean that the law is unconstitutional. When something is unconstitutional, it would be declared void. Alright? But non-constitutional does not mean it is unconstitutional. I hope I am clear. Alright. So we understand that the Constitution is the supreme law of the land, and the Constitution, whatever we have discussed can be summarized that the Constitution is the supreme law of the land and all other laws must be in conformity, else they are declared void or unconstitutional. In fact, they are first declared unconstitutional and then void. Excuse me there. So our take-home message is that the Constitution is the supreme law of the land and thereby it enjoys a special sanctity. One may can ask that why does it enjoy special sanctity? Because it draws power directly from the people, right? It derives power and authority directly from we the people of India. See, please understand that we are not agent of any political party or any religion. We are the agents of the constitution here. A seeker. Alright? Okay. So the next thing is constitution is also known as organic law. What do we mean when... Now what is organic? Well, organic in common parlance is life-giving. So how could a law be life-giving? Well, a law is said to be organic if it establishes an administrative structure. If it establishes an administrative structure. A law is said to be organic if it establishes an administrative structure. Now, is our law is an organic law? Yes, it indeed is. Because it establishes a three-tier administrative system. A three-tier administrative system with a central administrative system which consists of the executive, the judiciary and the legislature, the state administrative system which again consists of the state executive, the state legislature, the state judiciary and the local self-government at the grassroots level which consists of the panchayat and the municipality. So our takeaway from here is the executive, the legislature and the judiciary are the creation of the constitution. The executive, the legislature and the judiciary are the creation of the constitution. All right. We just understood that the executive, the legislature and the judiciary are the creation of the constitution. Now, since the constitution is the supreme law of the land, is the fundamental law of the land, is the reason we abide by the laws made by the constitution, the constitutional laws. But why do we obey the laws made by the parliament? Why do we obey the laws made by the parliament? And well, answer to that in three simple words is because the constitution says so. The constitution says so is the reason we obey the laws made by the parliament. And is the reason why we follow the judicial decisions, the decisions passed by the judiciary. Because the constitution has empowered the legislature to make laws, and the constitution has empowered the judiciary to interpret those laws. The constitution has empowered the judiciary to interpret those laws. So now we can also say that the constitution creates the executive, the legislature and the judiciary, and it also enables them, the executive, the legislature and the judiciary, by empowering them. The executive is empowered to implement, the legislature is empowered to legislate, and the judiciary is empowered to adjudicate. Alright, so what we can say that the constitution, so we can finally conclude that the constitution has created and has empowered. The constitution has also empowered the three organs of the state, the executive, the legislature and the judiciary. But now let's understand this. Let's just say that the legislature has been empowered by the parliament, by the constitution. But let's say that legislature ends up making a law which intends to undermine the supremacy, the authority of the constitution itself. What if the constitution intends or constitution makes a law which intends to challenge the supremacy of the constitution itself? Can the legislature make such a law? And the answer to that is yes, the legislature can make such law. However, that law would not see the light of the day, as the power to interpret such law is with the judiciary. I hope I'm clear. That the power to interpret such law is with the judiciary, and judiciary on judicial interpretation would declare such law as unconstitutional, and hence such law would be declared void. Alright? So this is where we make our final conclusion, that the constitution creates, empowers, and enables by empowering the three organs of the state, and it finally regulates the three organs of the state by restricting them. Alright? So therefore, what we can say, that the constitution not only creates, empowers and distributes the power among the executive, the legislature and judiciary, but also restricts and regulates their functioning so that the three organs work within the confines, function within the confines of the constitution. Alright, let's just quickly revise what we have seen so far. We learned that the constitution is a legal document. Provisions are legally enforceable. Violation of which attracts legal punishment. Alright. Constitution embodies the higher values and the higher goals which we wish to achieve. Constitution is the supreme law of the land. Therefore, Constitution enjoys a special legal sanctity. All other laws must be in conformity with the Constitution. And Constitution is an organic law. Organic means it establishes an administrative structure. And we understood that Constitution not only creates, but empowers as well as regulates the three organs of the state. The Constitution also defines the relationship between the state and its people, and that relationship is nothing but the citizenship. Constitution defines the legal relationship between the state and the people, and that legal relationship is the citizenship. And now please pay more attention. Please pay attention as we are now about to conclude our question. So it is because of the Constitution, and it is the Constitution which empowers and enables the sovereign, socialist, secular, democratic Republic India with its three organs, the executive, the legislature and the judiciary, to secure justice, assure liberty, ensure equality, and thereby promote fraternity along with unity and integrity of the nation. Come back, focus, need to pay attention. It is because the Constitution enables and empowers the sovereign democratic Republic India that it is able to ensure justice, equality, liberty, and is trying to promote fraternity among its citizens. In more simpler words, it is the Constitution which enables and empowers India to ensure the welfare of its citizens. Now imagine that what if the Constitution all of a sudden disappears? Then the sovereign democratic Republic India as the welfare state will also disappear. What kind of a state is India? India is a welfare state. So therefore we can conclude. And how is it functioning? Is it functioning? It is functioning as a welfare state because of the constitution. It is the constitution which has enabled and empowered constitution to India to ensure the welfare of its people. So the constitution is central to the functioning of India as the democratic republic as it is today. Therefore, we conclude our lecture that constitution is central to the existence of functioning of India as the democratic republic welfare state as it is today. And now let's just quickly revise, because if you're revising it during the exams, then it is these points which we would be revising that you are going to revise from here. You need not watch the entire video. It is from here that you need to watch. So we began our discussion with Constitution of India as the legal document. The Constitution is a legal document, that is, its provisions are legally enforceable, and upon the violation of the provisions, legal punishment is attracted. We then looked at the faith and aspirations of we the people of India. The Constitution embodies the higher values and the higher goals which we wish to achieve. Then we saw that the Constitution is also known as the supreme law of the land, and thereby it enjoys a special legal sanctity. All other laws must be in conformity with the Constitution, else they are declared unconstitutional and void. We understood that the laws which are not law of the land, which other than the Constitution, are non-constitutional laws. Non-constitutional does not mean unconstitutional. We then understood that our Constitution is also an organic law, as it establishes an administrative structure. India has three-tier administrative structure. We then understood that the executive, the legislature, and the judiciary are not only creation but are empowered by the distribution of the power of the three organs of the state are not only creation of the Constitution, but they are also empowered and regulated by the Constitution. We then also understood that the Constitution defines the relationship between the state and the people, which is citizenship. And at last we understood that the Constitution is the central to the existence of India as the political unit we know. What kind of political unit is India is? It's a welfare state. Alright? So Constitution is central to the existence of India as the welfare state we know. And this is where we conclude today's lecture. However, we are not concluding the question regarding the significance of the Constitution, as we'll be able to draw the significance only once we complete the syllabus, the entire syllabus of the Indian polity. So thank you. Thanks a lot for being patient and being with us. Thank you.